Good afternoon, everyone, and welcome to our webinar on enforcing breaches of restricted governance and confidentiality obligations. My name's Gwendolyn Davis, and I'm chairing the panel today. Accompanying me today are Nick McQueen and Tom Russon, who are members of the Commercial Dispute Resolution team and have worked with me on numerous cases in this area of law on the advisory litigation side. In addition, we have Charlotte Smith, who is a member of our employment team and is involved in drafting restricted covenant clauses and also advising on the employment issues when breaches are suspected, such as whether to guard and leave the employee, suspend the employee, or dismiss the employee. The reason why we decided to run this webinar was because we have seen an increase in employees taking confidential information from businesses and competing in breach of obligations. Ponymon, which is a US research institute dedicated to privacy, data protection and information security, has recently found that 59% of employees who leave an employer or are asked to leave take confidential or sensitive business information upon their departure. With increased home working due to the COVID-19 pandemic and ever-changing developments in technology, these figures are no doubt only likely to increase. The legal issues that arise in this area of law are vast. However, with a view to avoiding this webinar becoming too dry, we've aimed at talking you through the practical steps that businesses should look at taking. Firstly, with a view to avoiding or deterring employees from taking confidential information. And secondly, in the event that you suspect or know that an employee has taken confidential information. Again, the breadth of the subject matter and the fact that advice in this area will always be fact specific. We're going to approach this by way of our panel chatting you through a hypothetical case study which reflects similar circumstances to those which have arisen in a number of cases we have advised on previously. I'd like you to think about the following questions as the webinar progresses. What constitutes confidential information? Are your employment contracts robust enough in order to protect your confidential information? What to do in the event of a confidentiality breach or suspected confidentiality breach? And in what circumstances is it appropriate to consider using an injunction? When and how can they be used? Do they work, and are they likely to give you the outcome that you want? Hopefully, our case study and some of the practical tips we will provide you with today will assist you in considering some of these matters in the context of your own businesses. If you have any particular queries or issues in relation to this subject matter, then please feel free to direct them to us either during the webinar by way of the questions or follow up by email with any of us after the event. Our slides and a recording of this webinar will be posted to our website. So to start, I will ask Nick to introduce you to our case study.
So for the purposes of today, our client is a company which provides insurance brokerage services, which we will call Insure You Need. Our main protagonist is Leslie. So Leslie is a senior employee of Insure You Need, who has been employed for 3 years, first as an insurance broker, and then being promoted to senior insurance broker after 1 year with the company. In her role, Leslie has access to various confidential information, including client lists and pricing information. Leslie also has a team of 5 others reporting directly to her, and she is responsible for negotiating their salaries and has access to their qualification records. Leslie has also built up a strong relationship with the company's clients, and in particular since her promotion. Leslie has a company laptop and mobile phone, and like many people since March 2020, has largely been working from home.
So the first question for Charlotte is, what governs the relationship between Insure You Need and Leslie? Is there anything we should be aware of in terms of the employment relationship before we look at the contractual terms?
Yeah, so this is something that is often overlooked, but there are a number of implied duties that govern the employment relationship, and that is regardless of what the contract says. And some of these implied duties can be useful in cases where there's a suspected breach of confidentiality obligations or where departing employees are intending to compete. So the one to be aware of for these purposes is the duty of fidelity, or duty of good faith and fidelity. And this includes a duty on employees to not compete with their employers while they are employed. So if we go back to the case study example, Leslie is obviously employed by Insure You Need. So during her employment, she shouldn't also be setting up her own insurance brokerage or perhaps working for another insurance brokerage on the side, because that would potentially be a breach of this implied duty. But there is a limitation to that, because obviously what does acting in competition mean? It might mean different things to different people. So for example, let's say Insure You Need only brokers certain types of insurance. If she then goes and works for an insurance business that does something slightly different, then it's not necessarily going to be in competition in the usual way. So it's important that we have, further contractual provisions to define that. The other limitation on this is that it only extends during the employment period. So as soon as her employment has terminated, she could essentially go and set up in competition if there's no other contractual restrictions. The other aspect of the duty of fidelity is a duty to not misuse your employer's confidential information. But again, the question is, what is confidential information? So if there's no set definition of this, something that Insure You Need thinks is protected may not be protected. So that's why it's very important to have set definitions. Again, this is also limited to protection during employment. So the confidential information will not be protected after Leslie leaves her employment unless it's so confidential that it amounts to a trade secret. And that's only the most confidential of things, like formulas for specific food and drink products, for example. So not your general business information. So you can see the limits of that. The other thing to mention in terms of implied duties is if Leslie was also a statutory director, then she would also be subject to these additional fiduciary duties, which essentially goes even further than the duty of fidelity and would mean that she should put her employer's interests ahead of her own. And that can extend to things like disclosing her own wrongdoing and disclosing the fact that she might be preparing to set up in competition. If, for example, she wants to try and poach her team and take them with her, in reality, if she was a fiduciary, she should be disclosing that to her employer. But that only applies if they're a statutory director. So you can see that there are some useful things, but there are limits to the implied duties.
So, Charlotte, given the limits you talked about in relation to implied terms, with a view to companies proactively protecting themselves, what do they need to be considering at the point the employment contract is being drafted and entered into?
Yeah, so I think for our purposes, we can focus on three key areas of the employment contract. So the first is confidentiality obligations. So we talked about the limits of those implied confidentiality obligations, which is why it's really important to think about how you are defining your confidential information at the point that the employment contract is entered into. And that should be specific to your business. So sometimes employers will just use very generic confidentiality provisions, but actually you should really be thinking exactly what information does your business want to protect. So with Insure You Need, there might be lots of different things that they think are confidential, and these should be specifically listed. So for example, if they've got customer lists that have got their buying preferences on them, they should be listed. If they have pricing information about insurance products, that should also be listed. Anything else that they want to be confidential, like strategy plans, marketing plans, business plans, And also, if they want employee information to be protected, like salary information, other information about employees, that should be specifically listed in the definition. The other thing that the confidentiality obligations need to do is also expressly say that they continue after the employment is terminated, because again, we saw that that was the limit with the implied duty. So it needs to continue after employment. The second area to pay attention to is notice periods, and what goes in hand with that is garden leave. So for really senior and key individuals, you should be thinking about what notice period is appropriate, and often it will be between 6 and 12 months when we're talking about these senior individuals. And that can be used as a really key tool if you accompany it with a garden leave provision, because as we'll see, that's a way of potentially keeping people out of the business without having to rely on post-termination restrictions. And that should also allow the employer to sort of secure their own trade connections and customer connections during that time as well. And just one other thing to note on garden leave is that often employers think that they can just put an employee on garden leave even if they don't have the contractual right to do so. But it's actually really important to have a specific garden leave clause in the contract, because there's another aspect to implied duties, which often means that the employer should provide employees with work. So potentially if you put someone on garden leave without the contractual right to do so, the employee might say that actually my employer is in breach of my contract and therefore is released from the obligations. So really important to include that and say what can and can't be done on garden leave, whether the person should remain contactable, whether they should stop contacting other employees. And then I think the third and final bracket of clauses to look at is post-termination restrictions or restrictive covenants. So what are post-termination restrictions? There are obviously lots of different types. The most common type is a direct non-compete provision, which prevents people from going to join a competitor for a certain amount of time after employment has terminated. The other common ones obviously include preventing you from poaching other employees to go with you and preventing you from poaching the business's customers. But the problem with restrictive covenants is they are notoriously difficult to enforce. And there's, broadly speaking, two aspects to enforceability. The first is that there needs to be a legitimate interest to protect. And then secondly, the restriction needs to go no further than is reasonable to protect that interest. And often people think that a legitimate interest can be just preventing competition in itself. But that is not considered to be a legitimate business interest. You need something more than that. So, for example, protecting your confidential information, that might be a legitimate interest. Protecting the stability of your workforce and your trade connections, that could also be a legitimate interest. So once you have that, you then need to consider what would be reasonable to protect that interest and what should the scope of those restrictions be. And that is also assessed by reference to the specific individual who you want to be subject to these restrictions and how senior that individual is. What is their ability like to damage the business? What connections do they have with your customers? Once you've considered that by reference to the specific individual, then you also need to think very carefully about drafting the clause, and we'll see that that can often be very difficult to do and very difficult to enforce.
You say, Charlotte, restricted covenants are often difficult to enforce, and employers often get it wrong when drafting them. We act for both employers and employees, and the first thing I do when I look at a restricted covenant acting for an employee is to check its enforceability. So, Charlotte, can you give us an example of poor drafting of contract terms versus robust drafting of contract terms?
Yeah, so we've got an example here on the slide, and you can see that this says for a period of 2 years after their employment is terminated, the employee shall not compete with Ensure You Need. So we're just going to pretend that this is part of Leslie's contract. And you can see that that is extremely broad and for an extremely long period of time. So in terms of the length of the restriction, generally speaking, 2 years is just not going to be enforceable in employment cases. There might be different types of restrictions when you're looking at corporate transactions where something like that might be. But if we're looking at a pure employment case like we are here with Leslie, then that is going to be unenforceable as a restraint of trade. The other thing that this fails to do is it fails to sort of specify what it means by competing with Ensure You Need. So it just simply says that the employee shall not compete with Ensure You Need. So that could be interpreted in a different way by different people. And it goes back to the question of what is in competition. And the final thing that this doesn't do is it doesn't put any other sort of carve-outs or restrictions on the clause. So it doesn't limit it to, for example, a specific geographical location. So if you have something like this in your contract, if Leslie had this, then it's highly unlikely that this would be of any use if you then needed to rely on it to prevent her from competing.
So what would make a clause more likely to be enforceable? How would the drafting look, Charlotte?
Yeah, so we have an amended draft clause here on the slide. So this one says for a period of 6 months after their employment's terminated, the employee shall not be involved in any capacity in any business which is in the business of brokering or selling insurance products within the United Kingdom. So in terms of 3 things that this clause does that the other one didn't, period for which she is restricted is much more likely to be reasonable. So it's a 6-month period here, not a 2-year period. And let's assume also that Leslie's notice period is 6 months. That is a really good indicator of what might be enforceable for a direct non-compete provision. So much more likely to be reasonable. The second thing that this does is it expressly says what she can't do. So it says the employee shall not be involved in any capacity in any business which is in the business of brokering or selling insurance products. So it specifies what is meant by competition. And really you should go even further than that if you can. So again, if Ensure You Need sells specific types of insurance products, then it's better to be specific about that and state that within the clause. Something else that some employers do as well is they might actually list particular employers that they believe are competitors within the contract. So again, the more specific you can be with that, the better it is. And then the final thing that this does is it specifies which geographical location the restriction is limited to. So here it says the United Kingdom, so let's just assume that Ensure You Need operates throughout the whole of the United Kingdom. It's limited to that area. Again, if Ensure You Need only operates regionally, for example, in the region of Leeds, then you would restrict it even further and make sure that this is as specific as possible to that business and also to that employee. And obviously this is just a very high level example, and you probably will have a contract that's got very lengthy provisions, really specific definitions, and makes it as specific as possible.
Let's refer back to the case study. Let's say that Leslie had the first provision in her contract. If you wanted to amend Leslie's contract to make it more enforceable, as per the second example, how would you go about doing this so that the amendment is actually legally enforceable?
Yeah, that's a really good question, because in the case study, I think we talked about the fact that she joined as an insurance broker and she was later promoted after a year to senior insurance broker. So it's really important that you review contracts on promotion. And when she was promoted, hopefully she would have had a pay rise attached to that promotion. And therefore it's more likely that she will agree to enter into restrictive covenants because there's recognition of her seniority. She's getting a pay rise in consideration for entering into those restrictions. You need to make sure that you have consideration attached to the restrictions. Now, if you enter into restrictions when the employment starts, this is generally fine because the employment and then the ongoing employment can act as consideration for you entering into these. But it is more difficult if you then want to amend it during employment, as we're talking about. So again, make sure that any amendments are attached to a promotion or a specific pay rise associated with this. And then the other really important point to note is that if a court is assessing whether a restriction is enforceable, they will look at it by reference to the time it was entered into and not the time that you are alleging it's been breached. So let's say that Leslie had this restriction in right from the start, from being a more junior insurance broker, and her contract wasn't amended. She then left the business and started to compete. The court would assess how reasonable it was at the time she entered into this restriction. So actually it might not be enforceable. So that's why it's really important to always review the contract.
And that's a very important point and a good takeaway point, that review the contract on promotion. So for the purposes of our case study, let's proceed on the basis that Insured You Need has enforceable terms in place upon Leslie being promoted. So Leslie is increasingly working from home and it's likely that she will be in the near future. And Insured You Need have concerns over protecting their confidentiality information in the meantime while she's working on home. What can they do? How should they protect themselves? They can't see her. They don't know what she's doing. What steps should they take, Charlotte?
Yeah, it's a really good point. And, referring back to your statistic right at the start, it seems much more likely that people can just very easily take their employer's confidential information while they're at home. They could easily take a photograph of it, easily stick a memory stick into their laptop and upload it. And as you said, they don't have managers looking over their shoulder. So I think in terms of steps to take, the first thing to do is, as we've been talking about, is make sure that the contract specifically says what is confidential information, so people know whether what they're using is confidential information, and what are the restrictions on use of that confidential information. So that's always going to be your starting point. There are obviously other things that can be done as well. So you can restrict access to confidential information. Specific people in specific roles need access to specific things. And also you can use things like monitoring software so that you get an alert if, for example, some sort of confidential information has been downloaded by somebody. But again, just a word of caution with monitoring, that is sort of a whole other sphere in itself of data protection issues, other employment issues. And we did actually do a webinar on monitoring employees at home. So again, if that's something that you are thinking of doing to try and protect confidential information, maybe also go and have a look at that as well, which is on our website. So those are other things that you can do. And I think, it's just really key to make sure that employees are aware and they are trained on this issue and they know how serious it is. Because they might think, I'm just entitled to this information. I just want to take something with me to my new employer. But really, you have to kind of explain that this is akin to stealing from your employer. So it is a serious matter. And we will see when we talk about enforcement why employers take this seriously and why they need to protect that information.
Thank you, Charlotte. Some important points there in terms of drafting a contract and what clauses to put in and the considerations that need to take into account in order to protect your business. So turning to Tom and going back to our case study, Leslie later resigns. She has got a 6-month non-compete restrictive covenant, 12-month non-solicitation clause in her contract with post-termination confidentiality provisions and a 6-month notice period. So she resigns. What should the company do to protect its position? Tom?
Well, the starting point will be that she's handed in her notice. She needs to work her notice period, of course. But we know that Leslie's contract contains a garden leave clause. Insure You Need, therefore, has a decision to make about whether to enact that clause. Generally, as Charlotte said, the benefit of doing so is it's seen as a way of keeping the employee in question out of harm's way, without contact with clients, without contact, without access to your confidential information. But the working from home thing has perhaps changed that slightly. And if Leslie will still have access to clients because she's got phone numbers and has access to confidential information whilst on garden leave, actually putting her on garden leave might give her an opportunity to focus on her new business out of sight of Ensure You Need. So in that case, you might take the view, Ensure You Need might take the view, but it's best to keep her where you can see her and therefore best to keep her working. The next step will be to conduct an exit interview, which can be an important evidence gathering exercise if you do need to take future legal action. It's worth mentioning that employees are not generally under an obligation to disclose their future plans, but that's why the tone of the meeting is very important, and often we find that a departing employee might be more open where that meeting is conducted by someone who they've had limited involvement with. The obvious candidate is often HR, and where that meeting is framed more in terms of the company seeking to understand what they might have done better rather than adopting a more aggressive approach and making accusations at that stage. At the very least, it helps to have an independent person, so far as anyone can be independent, attend the meeting to take notes to avoid a later dispute about what might have been said at that meeting. At that meeting or shortly after, you need to be thinking about reminding Leslie of her restrictive covenants and her confidentiality obligations, and perhaps seeking written confirmation that she'll comply with them. We've seen examples where we've been acting for former employees where employers have demanded undertakings signed at the interview itself, sometimes immediately after allegations have been made for the first time. And we've even dealt with a situation where a managing director has, following that interview, driven the employee home and demanded that all information belonging or related to the company be handed back to him whilst managing director waits outside. We'd always suggest avoiding a heavy-handed approach like that, as regardless of the merits, regardless of whether the allegations are founded, it can give the employee helpful arguments that anything that was said at the meeting, anything that might have been agreed or signed, was done under duress and can't therefore be relied on. So we'd suggest if you do need to remind Leslie of her obligations, it's best to hand her a letter perhaps at the meeting and give her an opportunity to consider it and come back to you. Finally, as a practical point, really, you need to think about the confidential information that she might have. Make arrangements for that to be returned. Often that information these days is stored on a laptop or a mobile phone, and often that device belongs to the employer. So again, make sure that you make arrangements to have that returned, and consider, particularly if Ensure You Need is deciding to place Leslie on garden leave, think about making sure that she can't access the system remotely from that point onwards.
So let's imagine that Leslie says in her exit interview that she's moving into a different industry and therefore she's not put on garden leave. However, while she continues to work her notice period, Ensure You Need system notifies them that she has downloaded a list of customers and pricing information on her work laptop. What would you advise Ensure You Need to do at that stage, Tom?
Well, clearly it is a cause for concern. The point I think we'd be stressing to Ensure You Need is that there are examples where employers are adamant that something dodgy, something suspicious is going on, but actually on further investigation and on putting the allegation to the employee, there was a perfectly justifiable explanation for that. For example, preparing handover notes at the request of a line manager so that there's an efficient transfer to the incoming employee. The point to bear in mind is therefore that these things need to be considered fairly and examined. It's always best to put these points to the employee in question at interviews, give them an opportunity to respond. because there might be, and we've seen examples where there are easy and justifiable explanations for what's been going on, and you don't want to give the employee an opportunity to say down the line, if you do need to take action, that their employer had it in for them and that they've been treated unfairly.
Yeah, the importance of properly investigating is and documenting, in particular, those investigations. Because as you say, you don't know what's going to happen further down the line, Tom. Let's assume for our case study that subsequent to her exit interview, rumours emerge amongst Leslie's colleagues that she's going to work for a competitor of Insured You Need. So Insured You Need decide they're going to put her on garden leave. On the last day of her garden leave, their computer system notifies them again that Leslie has sent herself a list of customers, staff and pricing information. This is the last datum. So what should they do now? Slightly different circumstances.
Well, yes, you're on borrowed time, I suppose, as the employer. And I think at this point, the investigation has to ramp up to work out exactly what's happened. When I talk about ramping up the investigation, I think that should include searching mailboxes, interviewing colleagues, Leslie's colleagues, and taking witness statements from them where necessary. Ensure You Need might also consider perhaps what might be seen as more extreme action, so hiring private investigators. We've seen that used to good effect in these cases. We had one where former and current employees were tracked down and were seen attending meetings at head offices of key clients, and clearly when you can then put that evidence to the employee in question, to Leslie in this case, can be quite difficult for them to justify. That is, as I said a second ago, on perhaps the more extreme end of the spectrum, and that sort of action needs to be handled sensitively and needs to be backed up with the information that you do have and the risks to the business that you might suffer if you don't take urgent action. We also mentioned searching mailboxes, and generally that's a forensic exercise, can be undertaken with third-party specialists or by the employer's IT team or whatever it might be. But the important point is that it needs to be lawful. So employers need to consider what it says in the employment contract in terms of a right to search mailboxes and what it might say in any employee handbooks. Any search that is permitted needs to be reasonable and needs to focus on matters which are relevant to the investigation, because again, you want to make sure that there's no suggestion that that you as the employer have acted in breach of privacy or data protection obligations. That's particularly important in this case where we are talking about someone who is still employed, albeit on the last day of their employment. And that's because an unlawful search or a search that's in breach of the employer-employee relationship might give rise to an argument that Insure You Need has breached the contract, and therefore that the protections that they might otherwise benefit from fall away. Again, where the employee is still employed, you can require them to attend further interviews and perhaps put the evidence that you've obtained from other sources to them at that stage. Again, there's no obligation on most employees to explain what their future plans are, but as Charlotte said, where you're dealing with a fiduciary, so a director or other very senior employees, there is an obligation to answer questions honestly and even to disclose their own wrongdoing. With all of this, the key point really is to act as quickly as possible and to take specialist advice at the same time, and that's because an injunction, which might be the ultimate remedy that you need to seek from the court, is a discretionary one. And one of the factors that the court will take into account is whether the person seeking the injunction, so Insure You Need, has got clean hands. So where there have been excessively intrusive or unlawful searches, that might be taken into account by the court when deciding whether or not to grant an injunction.
So moving on with the case study, it becomes clear that Leslie has taken confidential information and is not legitimate for her to have done so. What practically would you advise the company to do as the next step, Tom?
Well, at this point, you've carried out your investigations. You've got your evidence. At this point, I think it's the right time for Ensure You Need to be drafting a letter to Leslie, which sets out in detail the company's suspicions, the basis for those suspicions, and considers seeking undertakings and the return of any information which Leslie does have. Generally, a confidentiality clause in an employment contract will include an obligation either to return or to destroy confidential information. So again, Ensure You Need has a decision to make as to whether it wants that information back or it wants to ask Leslie to confirm that she has destroyed it. For evidential purposes, it generally makes sense to ask the employee in question to return that information because, of course, then you can conduct your own searches and work out whether there's any further evidence of breaches within that information. Either that can be done, as I mentioned a minute ago, by obtaining a forensic image of laptops, mobile phones at that time, or alternatively making sure that those sorts of devices are stored securely so that if you can't resolve this without the need for court action, you can come back to those devices later on and review them, take an image of them at that stage.
So if we assume that when she's on garden leave, Leslie's mailbox is being monitored by a colleague, has an email that she's received from Ensure You Need's biggest customer. Great to see you today. Look forward to working with you again. So she's on her garden leave. What would you do there, Tom?
Well, it certainly doesn't look good, does it? Whilst on garden leave, you're generally required to make yourself available during working hours. Leslie might turn around and say, well, actually, this customer or the representative of this customer is a friend of mine and this was a social visit. But actually, if this was taking place during normal working hours, even though she's on garden leave, she is likely to be in breach of the garden leave obligations if that's what she's up to. So it should be said that that's unlikely on its own to support an allegation that she's in breach of any restrictive covenants or confidentiality obligations. The other point, since we are touching on social relationships, social meetings, social media is often a very useful tool to supplement any investigation. You would be surprised in about how many of these cases involve employees who have published their wrongdoing or published their intentions to go off and compete or whatever it might be, on LinkedIn in particular. So it's always worth looking to those sources for further evidence.
So let's say that the company finds out that she is in fact going to a competitor. Other members of Leslie's team also resign. It's clear that Leslie has been poaching the most qualified team members, and Ensure You Need is told by one of those departing employees that Leslie has offered them slightly more than the salaries they were on with Ensure You Need. Is poaching a breach of restricted covenant, Tom? And could this be a breach of the confidentiality provisions? Because how come that she has offered them slightly more?
Yeah, well, you're right, Gwen. I think there are 2 points. Firstly, poaching employees is likely to be a breach of any non-solicitation, non-dealing with employees of Ensure You Need. Charlotte mentioned at the start that restrictive covenants are subject to that reasonableness test. Often a well-drafted non-dealing with employees clause will be limited to employees which Leslie either directly worked with or was the line manager of, or things like that, to make sure that they're appropriately drafted so as to avoid being said to be too broad and therefore unenforceable. But subject to that and subject to the clause applying to the individuals in question, then yes, that will amount to a breach of covenant. The second point is that it seems that she has information about salaries. She is offering these former employees or soon-to-be former employees of Ensure You Need slightly more. And we know that that's information that Leslie had during the course of her duties to Ensure You Need. That information is likely to be said to be confidential information, particularly where the definition of confidential information in the contract expressly refers to that sort of information, as Charlotte said a few minutes ago. And the benefit of that claim, as opposed to a breach of covenant claim, is that the same reasonableness test doesn't apply. Confidential information, provided you can demonstrate that it is confidential, will remain as such and will be subject to those restrictions for so long as it remains out of the public domain. Just one point to mention very briefly, there may also be arguments that taking information about salary, particularly where it identifies named employees, amounts to a breach of data protection legislation by Leslie, so that's something else to bear in mind.
Yeah. Let's assume an email comes into Leslie's work mailbox after her contract's terminated. It's been sent to Leslie's personal email, but accidentally copied into a work address. It's from Ensure You Need's biggest customer, and it's placing an order and confirming that she's won their account and that they will no longer be using Ensure You Need. What action should Ensure You Need be considering now, Tom?
Well, that's about as clear evidence as you're likely to get, and the point that you move, I suppose, from the investigation into the considering or taking legal action. In order to prepare for that legal action, which is something that Nick's going to come on to, there are some important steps that can be taken. Firstly, it's often helpful to notify the new employer, Leslie's new employer, of the restrictive covenants that she's subject to. The reason for doing that and putting them on notice of those obligations is that you are then safeguarding or opening up the possibility of bringing a claim against that new employer where it can be shown that they were responsible for the breach of covenant or that they in some way procured it. The practical benefit of that is generally in the context of a claim for financial remedies, so aside from the injunction that you might need to seek against Leslie. And that's because the new employer is likely to have deeper pockets than the average employee, and therefore a claim for damages against them can often be a more attractive proposition. Speaking of loss and damage, it's important to keep records, and that's because a claim for financial remedies arising out of a breach of confidentiality or breach of covenant can be quite difficult to quantify and prove. In general terms, you often need to demonstrate that were it not for that conduct that was in breach of the obligation, you as the current employer, Ensure You Need, would have benefited from additional work or would have gained additional orders as a result. So it's important to be thinking about keeping records of anything that might be relevant and might support those arguments. The final point there on the slide is settlement. It's worth saying that where you do have an employee who is, or a former employee who is intent on breaching these obligations, then settlement might not be possible. But it's worth mentioning that you can obtain the protection that you need through agreement in certain circumstances, and that's something that I think Nick is going to come on to talk about shortly.
Thank you, Tom. I think one of the key take-home points from that is that don't assume. It's important that you investigate fully, because if you jump in, then you could be prejudiced in your position in the event of any further action you might need to take. Nick, Tom has mentioned at various stages potentially obtaining undertakings. What's the purpose of obtaining undertakings?
So in most cases, before any court proceedings are issued, it will be advisable to send the proposed defendant a letter before action, which seeks to resolve the issues without the need for formal legal proceedings. As part of that letter, undertakings can be requested. So the terms of the proposed undertakings will typically be the same or similar to the terms of any order that would be sought from the court in the absence of any agreement. So undertakings will typically include requests for the destruction or delivery up of confidential information, an undertaking not to use confidential information going forwards, details regarding how any confidential information may already have been used, for example, who has it been sent to and for what purposes, an undertaking that the employee will not commit any further breaches, an undertaking that the employee will comply with any post-termination restrictions that are in the contract, and finally, potentially an undertaking to preserve any relevant disclosable documents that may be needed for any later formal court action. So it's important to remember that undertakings are often just to hold the ring, so no urgent court action is required, such as an injunction. As such, the letter of claim, which requests for undertakings, will usually reserve the employer's right to take action in relation to any breaches in the event that loss and damage has already been suffered. In the vast majority of cases, a letter before action and the provision of written undertakings to an employer will be sufficient. The breach of those undertakings would then just be a simple breach of contract. In more serious cases where a more aggressive approach is required, we can ask for undertakings to be given to the court rather than to the employer directly. So this would require formal court proceedings to be issued and a cross-undertaking in damages to be given. But it does mean that if the undertakings are breached, the employee could be found to be in contempt of court, which is obviously a very serious offence. So just referring back to our case study then, so in the event that Leslie was caught sending herself a client list, she may well agree to give undertakings to return that list, to confirm what she did with it, if anything, and to delete any copies. So quick action in those circumstances may mean that that is enough. However, if we do know that Leslie has been competing whilst on garden leave and therefore while she was still employed, she's already obtaining orders from clients and is poaching staff, and if that's already caused loss and damage to Insure You Need, and Insure You Need wants to take court action, it may then be that we request that Leslie gives undertakings to the court to comply with their obligations pending a trial in relation to the loss and damage that's already been caused.
There's good evidence that Leslie is in breach of her post-termination provisions by using company confidential information. She's working for a competitor and is poaching staff and clients, so clear cut, but she still refuses to provide any undertakings. What action would you advise Insure You Need to take?
So if matters can't be resolved informally through correspondence and undertakings, the employer really needs to start considering commencing formal legal action and applying at the same time then for urgent interim relief. So interim relief will offer immediate protection, again, to hold the ring whilst a substantive court claim is progressed. So the main types of interim relief are delivery up or destruction of confidential information, the delivery up of any IT equipment. So again, that may be, as Tom referenced, to take images of and search for that IT equipment, orders to preserve documents or search orders, or injunctions enforcing restrictive covenants, and there's also the possibility of springboard injunctions. So this is important if the employee has started to compete with the business while still employed, so has effectively had a head start. This type of injunction seeks to neutralise any advantage the employee has obtained. So I guess just focusing specifically on injunctions then. So an application for an interim injunction is usually made at the same time as a substantive claim is issued and served on a defendant. It's important to remember that an urgent interim injunction is temporary until the substantive claim is actually resolved. However, often an interim injunction is actually the sole goal, and if obtained, a case can often be settled quickly thereafter. So urgent interim injunctions seek to protect the position between the date on which the proceedings are issued and the date of any final trial of a dispute. So that may be several months in the future. The types of injunctions which can be applied for include injunctions preventing an employee working for a competitor for a period of garden leave, an injunction to enforce post-termination restrictions, such as non-solicitation of clients or other employees, an injunction against using confidential information, and again, to destroy any confidential information. And again, there's the springboard injunction to neutralise any unfair advantage obtained as a result of an unlawful act. So injunctions are often granted based on written evidence with short hearings at which the parties do not have the benefit of disclosure or the ability to cross-examine any witnesses. Depending on the alleged breaches, applications for an injunction can be made without notice if there is good reason why the defendant should not be alerted of the application in advance. However, usually the courts will expect the defendant to be given notice, even if it's only a matter of days. The courts are very careful to ensure that the terms of any injunction are sufficiently clear to enable those subject to it to know exactly what they are prohibited from doing. So the defendants will be subject to the draconian sanction of contempt of court if they breach the injunction. Therefore, very important in respect of injunctions preventing the use of confidential information that the terms are very precise about what information is considered confidential and therefore covered by the injunction. A court may refuse to grant an injunction if the claimant is unable to specify with sufficient precision what constitutes confidential information. There therefore needs to be a good explanation as to why the information is actually confidential and needs protecting. Again, this goes back to the terms of the employment contract, as Charlotte discussed, and clearly defining what is confidential information. It's also important to note that the court has broad discretion to grant injunctions at an interim stage. So on a very high level, the court will consider whether there is a serious issue to be tried, whether if an injunction is not granted would damages be an adequate remedy, and where the balance of convenience lies between the parties. So the court will be looking who would be most prejudiced if the court decided to grant or not grant an injunction. As injunctions are restrictive, if the case is not settled, a speedy trial is usually listed, which means there is often a vast amount of work to do in a very short period of time. So speedy trials can be heard within a matter of months. So it's important to ensure that as far as possible, the terms of the employment contract are as clear as possible. So there's little room to have arguments about the enforceability of the terms. Also, employers need to ensure they don't breach an employee's contract, as again, this could render any restrictive covenants or contractual confidentiality obligations invalid. It's also important to ensure, as Tom mentioned, that the investigations are carried out swiftly and action is taken as soon as possible to minimise any damage. Any delay in the investigations can impact where the balance of convenience lies when the court is assessing that. So, for example, if the employer has already started at a new employer. So, again, going back to our case study, and Leslie, on the basis that she has post-termination restrictive covenants and confidentiality provisions, if she has taken confidential information, so such as client contact details, client investment data, something that is indisputably confidential, if she has joined a competitor immediately or even potentially whilst on garden leave, and if she's been poaching employees and clients, meaning that the business is incurring actual loss and damage, then Leslie may well face a court claim and at the same time may face an urgent interim injunction preventing her unlawful actions from continuing pending a speedy trial or some settlement. So faced with such evidence altogether, Leslie is likely to be advised to give some undertakings to ensure for you and to settle the matter as swiftly as possible.
Thank you, Nick. Tom and Charlotte. A lot of ground has been covered, but some key takeaways. Review your employment contracts. Are they fit for purpose? Check your precedent contracts to ensure they're up to date and reflect current case law. Particularly consider restricted covenants for key and senior individuals and on promotion. In the future, if you become aware that employees have taken confidential information and they're intending to breach restricted covenants, notify us as quickly as possible so we can create a plan. In the worst case, you might be looking at seeking an injunction, as Nick has mentioned. When recruiting key individuals, think about their roles, think about the information they'll have access to, as ultimately, all of that is going to be important to protect your position and make sure the covenants properly reflect what you need to protect. We'll be following up this webinar with a checklist that should help you assess whether you have things in order and what to do if things go wrong in the future. If anybody has any questions, direct them to either myself, Nick, Tom or Charlotte after this webinar. Thank you.